Hey, Patty. What's up?
Just went in and filed some papers on the behalf of the 8 pro se litigants for the King Lincoln case. We have some information we're wanting to put before the court prior to them making a decision on whether or not our intervention and motion for criminal contempt is further pushed from the court. Right now, the opinion and order from the judge say that we will not be allowed in the over 1,400 pages of documents with evidence of election fraud and destruction of records. The election officials will be blocked. What's important is that we've learned in recent research that multiple plaintiffs in the King Lincoln case knew nothing about the actions being taken in their name. Some didn't know that there was even a motion by us to intervene in the case. They'd not been updated and informed of any of it. Meanwhile, in their names now, this evidence that could help hold election officials accountable will be kicked out. And we feel it's really important that not only the courts see it, but that people know this is real American history, recent history.
Why do you have to join this particular election case? Why can't you start your own case?
Well, the thing that ties what we're trying to do into this case is that we have ballots from 2004 that were actually ordered to be preserved for this case. And so the destruction of the records, the only way to have the possibility of felony charges and criminal contempt for these election officials is through this case. It would not be up to us to convict people of that, but what we've asked is that the judge and the court review these documents and that we have a grand jury that will issue a report that will actually be studied, because where the case sits now, the attorneys for the plaintiffs missed the deadline on filing the documents. And what these actually are letters from the counties that were, in their own words, they admit to the destruction of the ballots. Those documents, it's 859 pages. The Secretary of State told her Voting Rights Institute group that she'd given them to the court. In that meeting that day, it was in August of 2007, in attendance was the NAACP, Greg Moore, Common Cause, the League of Women Voters, Case Ohio, members of the Ohio Election Justice Campaign, and others, and they were assured that the court had those documents and that Secretary Brunner was waiting for the court to respond and do something. That same month, in an email from attorney for the plaintiffs, Clifford Arnebeck, I was told that the records had been submitted to the court. We assumed then that they had. We wouldn't understand why anyone would lie about such a thing. And as we watch the deadline approach, there's a 1-year statute of limitations for criminal contempt charges on the destruction of records. So that date was coming up on July 10th of 2008, and as it came closer and closer, we wondered why had the court not done anything, and we wondered how big is the lie. And we thought the biggest possible lie would be that the documents had never been submitted to the court. So we came here to the federal court. It's part of the Southern District of Ohio. The case sits before Judge Marbley. We went into the clerk of court's office, which I was just in again today, and we asked to see if those records were here. Not only were they not here, but they didn't even know about them.
Wow.
Didn't know their existence. We were sent to the judge's chambers. They didn't know. Clerk of court didn't know. The building was physically searched to see if they'd be here. It's 859 pages, so it would be a lot of records. And so we took action with a group of 8 of us and filed to intervene in the lawsuit and filed for criminal contempt. There may be other ways that these people could still be held accountable, but we don't know what those are. From our research, what we know is this may be the only avenue for justice on this. And for some counties, it may not be as egregious. Ohio has 88 counties, 58 of them destroyed some or all the records. But on some of the counties, it was an intentional disregard blatantly of the court's ruling. I have a trail of emails amongst election officials right before they destroyed them, and they were making fun of it to the point that Keith Cunningham, the director of Allen County, in his email response where they were discussing amongst the election officials the idea of keeping and maintaining these ballots, Cunningham put in an insulting comment about the assassination of President Kennedy, and he didn't have time for saving the ballots because he was too busy trying to figure out who killed President Kennedy. I'm greatly dismayed that an election official would make such a joke in any way, but make it, and then within 2 weeks most of his ballots were destroyed.
All right. Well, thanks, Patty. Keep up the good work. Really appreciate it.
Thank you.
Hey, Virginia, you were with Patty. What's your take on this whole situation?
Well, this is the first time I've ever been to one of the motion filings, and I was very impressed with the expertise of Marion and Patty, of what they've done and what all the work that they have put into this process. And you know, it really upsets me that our Secretary of State, who is in charge of the election, is put in 1 hour since last July, which she should be doing this complete investigation of this, what went wrong. And it's just like she doesn't even care. And so I just feel that we have to get one time that we are going to win, and something will be done just for Ohio and for the United States and for the nation. You know, we've got to keep plugging along until we get that one thing that would help us get to the bottom of this.
What do you make of the fact that they've been moving really fast with Mark Deined's case, but this case seems to linger?
Well, because they don't want the truth to come out. I fully believe that. You know, I just believe they're stopping everything we do. They try to stop whatever would get the word out.
And the Democratic Party's been no help.
No, both parties are the same. They have an agenda, and they're not going to help us at all.
All right. Well, thanks a lot.
Thank you.
All right.
This week we, as the Ohio Election Justice Campaign's 8 pro se litigants that are wanting to intervene in the King Lincoln case, have asked of the court to reconsider. Our motion to intervene and our motion for criminal contempt have been blocked by the court on the behalf of the plaintiffs. What we're asking is that they take a look at our documents, and with the reconsideration motion that we just filed, that they seriously go in and look at it. This is a really serious time when investigation by the people, important documents and important stories aren't being heard, and problems within how the whole court case is proceeding. We've tried to address them with the court and get them just to take a look. There are many problems with this case, and so far we can't get a look into it at all. And the nation may continue to fall on its knees because of it. We hope that the people in this court will take a serious look at what we've asked. We've asked for oral arguments. We would like to actually speak with them, and after they hear us, we hope that they will understand the importance. If they decide not to, we'll work with that. We're actual witnesses to the crimes, so we're not going away. We're seeking justice on this, and I hope everyone gets themselves educated on it. It's really important.
Thanks. It's on. Just keep me in. So you're at what location? I just turned my camera on.